Kawupungi. Okay,
DJ ngathi nami ngizawuphunga.
Bhuti ukhona.
Ndeva kuthiwa kuyaphungwa, nami ngizawuphunga.
Akawupungi, iyakunceda loo nto. Iyakunceda. Kuthiwa le corona ifuna into eshushu.
Injalo. Khange ichaze, bathe yeshushu nje. Yabona?
Ngoku noba ilanga liyatshisa uvele ukona uba mawuye kule ti okanye kule kofu.
Uye kulaa kofu neti, yabona? Ya. Zawenza njalo.
Okay, ke bhuti. Right, sure.
DJ, DJ, we are.
Sihlalo.
Oh, we're back.
Ndike ndakhwaza apha ndafumanisa uba hayi sibambalwa abantu abakabuyi la.
So we're 23.
That ayithi into yobamba into ephungwayo.
Aye, sesikhona.
Okay.
Honorable members and our guests, we are back from a very exciting DM, very exciting presentation. And yeah, and I think we must have a second round at some point, because it's quite interesting. We are seated with in this country with jails, with jewels. Yes, that's the correct word. With whatever, and we are not utilizing them. I think our provinces deserve to have an understanding of this entity. I'm quite revived. Hey, the only thing, members, I've got a very, what is this? I think it's my heel is so painful. For two days, I walked barefooted. Hey, I don't know whether that is what is creating this for me, but what else can I do? A job. DG, let me just check if members are back. I see Honorable Mdabe, Honorable Bregram, myself. Who else is there? Zolan?
I'm also looking to.
You are muted. I can't hear you.
I'm not.
Oh, okay. I can hear. Okay.
Yes, I'm looking there. I see yourself, Honorable Benner, Honorable Mdabe. Yeah, only those.
No, we are going to. We did say that we are going to be back at 1:15. Now it's running for 25 past.
But we must be pambi.
Uzawukhutshwa wena kule committee. Sithi abantu abazawutsho uba makuthini. Utheni ngoku uzawuxelelwa nguwe uba masithini. It's Honorable Bregram. Unantsika, the new member, Honorable Makubela, had connection problems. I think umthumelele umnikela number yabantu be IT.
Yes, I did.
Oh, you did. Ne?
Yes.
Oh, okay. All right. Can we, Digi, over to you. Mr. Lamati. Mr. Lamati upi na betu. Usayo ukiaga kona. Mr. Wababa.
Ndikhona sihlalo.
Oh, okay.
Ndikhona bensazama ucofa le nto sometimes iyasokolisa yabona zathi ndophula esi screen.
Oh, okay.
Mute.
That's why mna ngamanye amaxesha ndidla ngoyiyeka ndingayicimi. All right, over to you.
Yeah, the next presentation that we're going to get is the presentation on the essential services.
But before that, I think it is important for the entity that is located, the issue of essential service, which is chaired by Advocate Bono. I think it is important for them to understand why we feel that we need to be taken through on the issue of essential service so that we are empowered. Because if then we are not empowered, it's going to create a challenge for us to conduct to conduct our oversight. And essential services, it's one component within the labor environment, which I think is very, very important. So we wanted, it's because of that, that we thought that let's invite Advocate Bono to take us through. The interest is because he was once, we had a session where he was a facilitator, and in that he didn't finish the session because he had to run to an area where there was an industrial action, and as the chair of that, he needed to go and attend. And I then thought that, well, if we have people who are also doing that, we must then be empowered. We are aware that it is located in the in CCMA, but we thought that as the chair of that unit, he must then take us through of exactly what is it that he is doing, and what then is the impact of what he is doing into the labor environment, and how then, as the public representatives deployed in this committee to oversee the department, we can then be empowered. And I want in this session that we are welcoming them, for them to understand the background of why they are here. Let's apologize. We know that you were to start at 2, but unfortunately we couldn't. We had a very interesting and informative presentation from the Productivity SA, and we couldn't just cut them because we know that we went into your time, but our apologies. Over to you, DJ.
Thank you very much, Chair. Chair, you've raised the points I was going to raise, that where this work is located. I think it will be prudent that we ask the Director CCMA to just have his opening remarks before Advocate Bono takes over, Chair, if you agree.
No, that is fine.
Okay.
Why is it that I don't know?
He's not Mukhajana. Chair is Murajan.
Okay. Director Cameroon, let me take the easiest one, because I don't want to find myself saying things that. Over to you, Executive Director.
DM says we are closeralizing him.
Okay.
Limubita kaSizotho.
Uzawuthi shu.
Over to you.
Over to you.
No, thank you very much, Chairperson. Thank you very much to the Director General of the Department of Employment and Labor.
You are a bit soft.
Andiqhelanga uba soft man, ndisaqala Chairperson.
Oh, okay. Oh, usa gear up.
He's warming up, Chair.
Okay. So to all the members and the DG, my colleagues, and also my colleagues in the Essential Services Committee. I saw some of them are also present, Chairperson. Chairperson, I must say also that I was motivated in doing this part that I'm presenting now, which is not necessarily in the slides or in the presentation, but it is necessary. I was motivated by what the Deputy Minister, sorry, I made a mistake, I apologize. I must acknowledge our Minister in absence. I must acknowledge the presence of our Deputy Minister. I apologize, Deputy Minister. I acknowledge you. It was my mistake.
Apology accepted.
Right. Thank you. Chairperson, I was motivated by amongst other things, that the closing of the Deputy Minister, she used a very important expression. She said that it is important when we're talking about Productivity SA, that we must not lose sight of its founding documents, which I found to be quite compelling, because every structure that exists, it does have its founding documents. And the approach that I'm taking is motivated by exactly that I will just briefly, not in detail, talk about the founding structure of the Essential Services Committee. And I think that is important to deal with. And I must say that the presentation that will be submitted by Ubono, the Chairperson, it's a presentation that we both endorse. I have had sight and contribution into the presentation, and that's very important. And Chairperson, also what is also important, when I listen to Productivity SA as well, that it is important that it be understood that the Productivity SA is not just also an entity of the department. It is also an important entity that works with the CCMA, particularly on issues of job saving and retrenchments in general, because they sit in the Single Adjudication Committee at the CCMA. And of course, you also have the UIF. And what we've always said, DG, as you'll remember, that we always emphasize that when we're talking about the Dell family, it's important we always acknowledge the synergy, the integrated approach that we apply when we deal with issues. And as I'm sitting here, Chairperson, I'm happy to hear the positives also that comes from the presentation of a Productivity SA. And I know that Advocate Bono is also the adjunct professor. And I can tell you, Chairperson, that I saw that Chairperson appreciates that when we have excellence celebrated. I was also happy to be appointed by the University of Johannesburg in November as the Professor of Practice in the University of Johannesburg. And I think that's a very positive thing. And I was listening to Professor Mtuaba. So we are providing you with quite a quality input, which I think at some point, I think Professor Ndaba touched on it, that the qualities and the resources that we have, we can never know their worth until we use them. And I hope that we will be able to go to that extent. Now, having said so, Chairperson, I want to start first with the foundational issues of the Essential Services Committee. One of the things that I will talk about is issues of culture that is impacting on the functions of the Essential Services Committee. And I can say it outright, Chairperson, that when we're talking about the Essential Services Committee and our execution of this, there are certain specific issues that will come from the rest of the presentation, but I'll just deal with the foundational issues. Firstly, that it is important to note, Chairperson, that in the Essential Services Committee, it is a committee that is established by the minister, of course, after consultation with NEDLAC. This is regulated in terms of Section 70 of the Labour Relations Act. And I can confirm you without doubt, Chairperson, that the establishment of the committee, its founding DNA, its existence, it owes it to the Labour Relations Act. It's very important that we establish that, because sometimes it is quite disconcerting when you hear that people seem to interpret the Essential Services Committee as a committee that comes out of the province of the LRA. It's not. It is born and brought out of the Labour Relations Act. It is very important. And if you look at that important Section 70, it tells you that not only is it established by the minister, after consultation with NEDLAC, but it is also established under the auspices of the CCMI. Chairperson, when you opened, you mentioned that it is important, and like DG said, that it is important that we always don't forget where the location of the ESC is, that it's part and parcel of the family of the CCMA, and the CCMA family is part and parcel of the Department of Employment and Labour, led by the Minister of Labour and the Deputy Minister of Labour, and overseen by the Portfolio Committee. That is very important to mention, Chairperson. The second part, which I think, because it's a workshop that we're at, it is important also that I mention that there's this important part called the composition of the Essential Services Committee. The composition of the committee is established in terms of Section 70, capital letter A. That's the provision that regulates how the essential services is composed. It's important that it be noted. Secondly, before the amendment, I think of 2015, the committee had just the chairperson and 2 members from each and every one of the social partners, government, business, and labor. It only had the chairperson. Now, after the amendment, they added a deputy chairperson. Joyce Nkopane is the deputy chairperson who's deputizing Advocate Bond. And then we've got 2 members from each social partners, 3 of them, which constitute the Essential Services Committee. So from the structure point of view, from the foundation point of view, it's important that it be understood, because its powers, its functions, and what it can or cannot do must be interpreted and seen within the context of that legislative framework called the Labour Relations Act. And in addition to that, the Act does not just establish a committee for the sake of it. Its jurisdiction must also be defined, its area of operation and its jurisdictional power must be established. And it is indeed, Chairperson, established. If you look at Section 70, capital letter E of the LRA, it tells you that the jurisdiction of the Essential Services Committee is throughout the Republic. So ESC is not established to operate in Gauteng or to operate in Limpopo. It operates throughout the country. This is the legislative provision. The same provision will tell you, Chair, that the seat of the ESC, it's where it's located. And the ESC is located at 28 Harrison, which is the headquarters of the CCMA. That's where you'll find the Essential Services Committee. What is also important in terms of the provisions, Chairperson of Section 70, is that it also tells you, and this is one of the reasons why I'm submitting, is that the Essential Services Committee, in terms of the amendment, the director of the CCMA is appointed as the accounting officer of the Essential Services Committee. This is important. And I can tell you, Chairperson, for years, we've worked exceptionally well with the ESC, particularly with the Chairperson, because we have a long history on issues relating to the ESC and challenges it has faced and all the waters that we've navigated. So that is, to me, a perfect statutory confirmation of that relationship. In addition to that, Chairperson, like the CCMA, the Essential Services Committee also has what you call rules, but in this case, we're talking regulations. And I'm very privileged, Chairperson, to say that in the development of the regulations of the ESC, I was part of that with the Chairperson. I remember exactly what we went through and the versions we had to go through in the establishments of the regulations. And it's important, therefore, to comfortably say that the Essential Services Committee, like the CCMA, it does have its published regulations, which are regulated in terms of Section 70, capital letter F. And these regulations are very important. And I'm sure, Chairperson, by now, you would have noted how important the role of the minister and the deputy minister is, because not only in terms of the appointment, but also in terms of the establishment of these regulations, these are done by the minister together with the committee. And that's why we've got our regulations that are currently applicable. Chairperson, one of the challenges that you will see in the presentation, and I will not steal the thunder and talk to them because Upona will talk to that. One of the things that is a major issue for me and a major issue for the committee is that the operation of the Essential Services Committee is never understood in terms of the culture and the environment within which it is operating. And if you look at the size of the committee and you look at how it is constituted, people tend to think that when you're talking about a committee of the essential services, we are just talking about a committee that is just established by the board of the CCMA. It's not. This is the committee that is established by a statute. But the operation of the essential committee, essential services, is operating within a certain context, within a certain environment. And Chairperson, part of the discussion that one is expecting, as you will see from the presentation, is that unless we fully appreciate and fully understand the environment within which the ESC is operating, anyone who judges the effectiveness of the ESC is going to misdiagnose it, because the environment that it's operating under is quite hostile. I'm not talking about environment in the CCMA. I'm talking about the environment in the country. And what is also coming out of the presentation, which forms part of the culture and environment issue that I'm talking about, is the understanding of the content and scope of the powers of the ESC. Whenever there's a discussion about the ESC, the intervention that it has to make, the timing it has to make, what must be understood is the culture and environment within which it's operating. Chairperson, you see, if you look at the Constitution of the Republic, you will note that one of the things that is confirmed is the right to strike, which is contained in Section 23. And the right to strike is historical in South Africa. I don't have to teach you, because I'll be teaching the converted, especially you, Chairperson, from the organized labor. We're from how we know what the circumstances. And when you're talking about the functions of the Essential Services Committee, you are actually touching on the sector that you operated in, which is the health sector. Just to share a bit of experience on the culture where I'm driving at, is that I remember when I was at Nahau, there was a time whenever workers organized a strike, and the General Secretary then, Comrade Fikile Majola, would not only call just workers, everybody directly and indirectly connected with Nahau will be expected to be with the workers and march in the streets on whatever is at issue. Whether you are the CFO, whether you are the cleaner, when it's time to march, everybody marches in pursuit of the workers' grievances and interests. But what is important, Chairperson, I remember at the time, was that you will find in circumstances where that you have a designation, which is contained in a promulgated designation that says you are in the nursing sector, you are in the jurisdiction of the courts. So therefore, in terms of these designations, you are prohibited from participating in a strike. Now, Chairperson, I'm raising this contradiction because it's important. There's something very important about issues, what I call this cognitive disruption, is that the way we understand the essential services operate, the one level of understanding it, its operational legal framework. But the environment that I've just displayed now, you will find that the sectors that are designated as essential services are proceeding to continue on a strike or an industrial action. Now, as a result of that, therefore, you find those contradictions. On the one hand, we are expecting that in the operation of the ESC, that there'll be a rule of law. The rule of law in simple terms, because we are operating in a South African context that has not only a constitution, but you have a constitution that has the supremacy clause, which then advances a principle of constitutionalism. The principle of constitutionalism has as its DNA the rule of law. The rule of law means, therefore, that the designations that the ESC issues, promulgated as such, they are law. And therefore, if you look at the definition of law, it includes exactly what I just talked about. So then what happens when such a designations and determinations are made by the ESC and said that we've designated this as a maintenance service, we've designated this as essential services, but you've got workers' grievances which are foundational to our triple crisis, which is issues of unemployment and poverty and inequality. So if workers then march in order to pursue those important interests, which are historical based, on the other hand, you've got essential service that says, but while I accept your right to strike in terms of Section 23, but we've got a fundamental problem. So this is what I call the cognitive disruption, because we do have an understanding what the ESC has determined what must happen, but we've got workers' rights contained in the Constitution when they march in pursuit of such interest, but then you find a collision. This collision is a collision which is created by the Constitution itself and the statutes that are issued in terms of that. So, Chairperson, you do have these important legal and socio-economic conflicts which require resolution. That's where the ESC finds. So, if you find a home, a private home somewhere of the agent, that whose workers are now on strike and they're designated not to be on strike, they're exercising their right in terms of Section 23. Then the chairperson of the ESC gets a phone call that there's a strike in that home and you've designated, go and resolve it. Now, the question I'm asking, Chairperson, given the powers and functions which are defined in the Act of the ESC and the issues that relates to the enforcement of such, how do you resolve such a dispute? Because that's not a policy issue. That's not just a legal issue. It's a socio-economic, legal, political problem. So you've got a multiplicity of issues that requires different jurisdictions to resolve. But the painful thing that eventually, when there is these perceptions of non-intervention by the ESC, such failure is associated and assigned to the ESC. Why is that? Is the question I ask myself. Because the powers that the ESC has is very limited. not only because they choose to. It's not because of that. We don't choose to be limited by that, but that's the framework of law that defines how far we can go, how far we can do this. So as you hear the presentation that is going to be presented, it is important that you understand that culture, that the culture of the rule of law, as we would like to have it, it's not at that level. So from such an abnormal situation, which creates statutory and constitutional contradiction, it requires a constitutional and a statutory solution. But what we have currently, it's not that. These are the limitations that we have as a committee. Now, having said so, Chairperson, as you listen to the presentation, as the Chairperson presents the context, the challenges that we face, it is important that this be understood. You see, Chairperson, one of the things that we are perfecting is to ensure that the dispute resolution process of the CCMA as an institution that is synchronized with the dispute resolution process of the ESC. If you are going to resolve the essential services question, you've got to get it right there. Because you do find matters referred to the CCMA, and you find that what is actually the dispute referred to the CCMA, and you look at the facts, you will know that the dispute turns on the facts which are a jurisdiction of the ESC. You see, Chairperson?
Can we? I would appreciate. I'm worried about time.
Okay, Chairperson.
If you can wrap up.
Let me end at that, Chairperson.
Okay.
That's okay.
Okay. Thank you very much. Thank you very much. Some of these issues are quite interesting, and I think these workshops, if we have them from time to time, we are really going to be empowered. Chair of Essential Service Unit, can you then take us through the presentation? Is Advocate Bono in?
Yes. Chair, I was just trying to move my router a bit to make sure that I've got the best coverage. Chair, to yourself and to the portfolio committee members, as well as the Deputy
So sorry,
Minister.
Honorable Chair. Can we ask Advocate to switch on the lights in the room he's in so that you can see him properly? Because it's too dark. You are dark yourself, but now you are more in the dark.
I hope this works.
Yeah, much
I hope
better.
this works.
That's better.
That's better.
Okay. Thank you, DM. Okay. Can we have the presentation flighted so that we can, so that I can run through? I don't know whether is Zolani going to project it, Chair?
Chair, if I may answer, Mr. Wababa said that Advocate Bono will write it himself. I made him a co-host because of that.
Oh, I was not told of those beautiful news, but it's not a problem at all.
We are
going to quickly open.
And as you get up,
DJ Ngolo.
Singasokolisa umntana abantu abakandakazi simncede.
Ayazi
Share screen.
Just have to open it, Advocate Bono, open it and then share.
Slalo, I don't have access. Zolani is not. Zolani, can you allow me? It says only the host can share the
I
screen.
have allowed you access because you are co-host.
It's open.
Bono. Then there's a share button at the bottom.
Okay, it looks like now it's going to come up. Yes. Thank you.
There you go.
Is my screen visible to everybody?
Yes, we can see it.
Chair, can you? Okay, thanks, DG. Chair and the committee, I'm not going to make any further opening remarks. I think the accounting officer has done so, Cameroon. But we're quickly going to deal with what is an essential service. And then I'm going to spend a little bit more time on the issue of strikes, talking about limitation, because as we know, people who are in essential services, their right to strike is limited. Then we'll talk a bit about minimum service agreements, as well as the role of the committee and its operations, the work that the ESC has performed. We've taken it from 2015, which is really when the law changed, and we're able to track the successes and the challenges and the failures throughout. And then lastly, I'll deal with the challenges as well as the assistance that we require from the portfolio committee, if possible. Honorable members, as you would know, the essential services are defined in terms of Section 213 of the Labor Relations Act, and it is those services that, if interrupted, may endanger life, personal safety, or health of the part or of the whole population or part thereof. In that definition, the legislature included parliamentary services as well as SAPs. Now, these two are not designated by us as the ESC, but they are designated by the legislature, and I'll deal with that later. Very important to know, we found that there's always a misunderstanding, and people think that it is workers that are essential, and they sometimes call them essential workers. It is not. It is actually the service that is essential, and we look after the service, and the difference will become clearer as we proceed. As I indicated, if you are rendering an essential service, in terms of Section 65, your right to strike or to be locked out is limited. You need to have an MSA in order to exercise your right to strike, and your disputes generally may be resolved through interest arbitration. One of the issues that I'm going to talk about is the current provisions in the Labor Relations Act, which require employees to ballot for interest arbitration, and how—
Sorry, Advocate. Sorry,
yes,
Advocate.
Chair.
Please, if you can, don't use abbreviations. Assume that we don't, yeah.
That's fine. That's fine. That's fine, Chair. So I was saying the current provisions of the Labor Relations Act, which require employees to ballot for interest arbitration, and how, as the ESC, we think that this is some form of hindrance. Let me just give a very, very brief background of what we do at the ESC. And I've classified this into two, as primary duties as well as secondary duties. But primary duties, in our view, are four. One, we conduct investigations on whether a service is essential or not. So we would get a referral that says, come and investigate if fire services is an essential service. So we would go and we would conduct an investigation as outlined by Cameroon. That investigation would be national, and we would look at whether, in fact, if that service is interrupted, there's any likelihood of there being an endangerment to either life, the people who might die, health, people's health will be affected, or safety. And based on that evidence, we would then designate that service or not designate it. So that's the first one. The second one is that we facilitate what is called minimum service agreements. We go in and we help parties. We say, you are in an essential service, you are in a hospital. In this hospital, if the unions call a strike, some of you need to remain behind to ensure that the lives of the patients and the health of the patients is not compromised. So we facilitate those minimum service agreements, and the unions would together with management, would agree and sign an MSA, minimum service agreement. If they fail to agree, we have the right to determine. So if we give them a period to say, negotiate, we give you 2-3 months. If you're not done, we will come in terms of Section 72(2) of the Labor Relations Act and determine those minimums for you. So that's the second part that we do. The third role is that we resolve disputes in essential services. On many occasions, you'll find people saying, the employer will say, we are rendering an essential service. And the union will say, no, we are not rendering an essential service. In that case, we have to be arbiter and decide whether they, in fact, are rendering an essential service or they are not. The last one is that we determine maintenance services. Maintenance services relate more to machinery, and I'm going to define what a maintenance service further on. What happened now? Okay, and then our secondary duties, there's 5 of them in the Act. One is that we do what is called monitoring and evaluation. We monitor the implementation and observance of designations, minimum service agreements, and minimum service determinations. So we would go in either when there's a strike or subsequent to a strike to sit with the parties and to say, what happened? This is an essential service. Why did parties go on strike in an essential service? We take that information. That information forms part of our quarterly report that goes to the governing body of the CCMA. So we look into why is there non-compliance? Sometimes we have found that it was not only a question of non-compliance with the essential services law, but sometimes it was not a strike as defined in terms of the Act. So that's one of the secondary duties, that we do. The second one is that we promote effective dispute resolution in essential services. So we look at the dispute resolution mechanism of a bargaining council, for an example, and we would see if we find gaps. We would then raise those gaps to say you need to close these gaps to ensure that there are no disputes that end up in strikes. And I'll give you a few examples. Let me take 2. There was a strike at Baragwanath in 2019. We went in to investigate why did PSA and NEHAU go on strike. We discovered that the strike was a consequence of a collective agreement which had been signed by the parties. And this collective agreement provided that after you've been assessed performance-wise, you will be paid a bonus. And the employer did not pay the bonus. And so both PSA and NEHAU and the other unions were up in arms, and this ended up in a strike. And we noticed that the only thing that you needed here was to have a clause similar to Section 33 of the Labor Relations Act, which is an enforcement clause for your collective agreements. They did not have that clause. A second example is in local government, and we've had a few of these, the latest one being Amatola District Municipality. Went on strike, same issue. There's a collective agreement to pay increments. The employer paid one portion, did not have the money to pay the second portion. This resulted in a strike. But if you had a mechanism to enforce the strike, to compel the employer to its obligations in terms of the collective agreement, you would not have had a strike. It would have been a simple route for enforcement. As I leave this part, Chair, I just want to highlight that Currently, the public service is up in arms about non-payment of agreed increases. And that was a collective agreement. And the PSCBC does not have that enforcement clause, which has resulted in the current situation that we find ourselves in. We also developed guidelines for negotiating minimum service agreements, and we've done that. And Cameron appropriately raised the issue. We worked with the CCMA in doing this. We initiate investigations on whether or not a service is essential. Sometimes we don't wait for parties to refer to us that we investigate a service. Sometimes we look at what are the ILO trends, what has the ILO looked at recently, and we initiate an investigation. We've done a few of those. Quite recently, we were looking at ports and marine services, which the ILO had looked into, and we thought we should also follow suit and look into them. And the last secondary duty is we appoint panels to assist us or to perform the work that we do. Those panels are either chaired by myself, by Joyce, who's the deputy, or by a senior commissioner of the CCMA. And we have assessors, we've trained union officials and some employer representatives who we can call upon to form part of these panels when we do cases. So I spoke about the first primary duty as being designating services, which is in terms of Section 71. Now, there are two ways in which services are designated. One is through legislation, which is what I indicated now, SAPs, as well as parliamentary services. And the second one is through the ESC. So there are only two ways in which a service can be designated as essential. Now, services that are designated through legislation, as I've told you, is Parliament, it's SAPs, but there's also electoral services, which are designated as essential services through the Electoral Act. Disputes about these services are dealt with by us. So they come to us, and I'll cite just two quick examples. One, we've entertained a dispute recently, which we also entertained quite a few years ago, where provincial legislatures, came to us and argued that the work that they're doing is similar to the work that Parliament is doing, and therefore they fall under the designation of Parliament. So that's just one that we've dealt with, but we've dealt with a number of these. We are currently working on a minimum service agreement for the Electoral Commission, and all that work is done by the ESC. Just a very brief on the Section 71 services that we've designated, and these I've classified them and not given you the whole list. I've just classified them. For example, in local government, we've designated traffic, we've designated clinics, health, the distribution of water, firefighting, refuse collection, etc. In public health, we've designated nursing, we've designated emergency medical services, that's EMS. We've designated medical officers and other support services that go with it. In social development, we've designated nursing, caregiving, catering, which is rendered in places of care, children's home, as well as old age homes. We've also designated mental health care services. We've designated the regulation and control of traffic, security services at airports, educational institutions, as well as stadiums. We've designated generation, transmission, and distribution of power, which is primarily rendered by ESCOM, as well as courts and correctional services. So these are some of the designations that we've done over the years, and I've just sampled a few of them. Now, coming to this whole concept of minimum services, we all know that there were amendments to the Labor Relations Act in 2015. And one of the most important amendments in that set of amendments was that the value of minimum service agreements was increased, and the Essential Services Committee was given the powers to determine them. We did not have the power before 2015, for the first time, we were given the power to determine them. What we did, as the law changed, we then approached the sectors to say to them, kindly start negotiating your minimum service agreements because the law has changed and we now have the right to determine them. In local government, I'm very proud to say, as early as November 2015, at the South African Local Government Bargaining Council, we concluded a minimum services framework agreement, and they asked us to sign the framework agreement and that the numbers be dealt with in each and every municipality in this country. And that's the program that we embarked on, working together with the South African Local Bargaining Council. In public health and social development, it's worked slightly different. We are yet to conclude the framework agreement. There's been some degree of resistance to minimum service agreements. We have only, towards the end of last year, managed to get some degree of cooperation in that in the PSCBC, in the Public Service Coordinating Bargaining Council, they've agreed to establish a task team which is going to talk about minimum service agreement. Now, this is 5 years down the line. The law changed with effect from the 1st of January 2015. And we think that we've tried. I personally wrote an article about the importance of minimum service agreements, which was published in the COSATU newsletter. So we've done a number of things to try and make sure that we encourage parties who are rendering essential services to have these minimum service agreements so that when there's a strike, the service does not suffer, but the strike is also not compromised. So we try and get that balance going. This is just an example to demonstrate an essential service. People think that it's a numbers game. It's not really, these numbers are not thumb-sucked. There's a science to how you get to these numbers. So if, for an example, we look at the big circle as being the essential service. So let's say the big circle is a hospital. What the employees in the hospital, they will agree on the numbers. And the question is always, what is the least number of employees that are required in order to render essential services in a particular unit or department? So you would then break it into pieces. You would look into that hospital. How many nurses do you have in casualty? In casualty, I've got 20 nurses per shift. What is the least number of nurses that I need? You might find that in casualty, you need 18 in order to continue with the service. But if you look in the same hospital, if you look at OPD, outpatient department, you might have the, let's say 20 nurses again, servicing OPD, but your minimum there might be different because the threat to life is less in OPD than it is in casualty. So you might find that in OPD, you're able to say, we can work with 12 and 8 can participate in a strike. So the essential services now shrinks and it reduces into the, I think the color is pink. They say men are colorblind, but I think that small circle is pink. So it would be only the part that is pink. It would only be that number and the rest of the people may participate in a strike. So, and we say you can't agree on a minimum, which is what in the PSCBC many unions wanted to do, have a standard minimum. Say, for an example, it's going to be 70-30. It doesn't work like that because one hospital is different to the other. So you can't have a flat, you must look at it per institution. So that's just an example of how, what is an MSA and what it looks like. Also, with the amendments to the Act, for the first time, we had the definition of a minimum service, which we sponsored to the Department of Employment and Labor, and the legislature accepted it, which means that a ratified minimum service or determined minimum service means the minimum number. And the word minimum is very key because when you negotiate, you find that the employer wants the maximum and the unions want the bare minimum. It's not. It's the minimum number of employees in that essential services who may not strike in order to ensure that the life, personal safety, or health of the whole or part of the population is not endangered. We thought we'd give stats to the portfolio committee of how our work has progressed so far. I must mention that before 1995, there were only 2 minimum service agreements that were signed in this country. Where we are sitting currently, we're sitting with 224 minimums. In municipalities, they've signed 35 MSAs. We've done 43 determinations, and that gives you a 78. We've also looked at water boards, where 6 of the water boards agreed by themselves, 2 we've had to determine. Social centers, we've dealt with 16, all of them agreed. We haven't had to determine. In old age homes, we've done 98 agreements, 16 determinations, and that's 114. And in other institutions, those would include universities and so forth, we have done 8. That gives you a total of 224, which we think is quite something to have achieved over the small time. Also with budgetary constraints, we have to only pick a few to do. We can't do everything. Otherwise the DG might punish us. We must work in terms of the money that is allocated to us. Section 73s, as I indicated, these are disputes on whether a service is essential or not, or it falls within an essential service. And quite interesting with Section 73 is that Section 73.3 requires that these disputes be heard as soon as possible. Our average turnaround time is 2 to 7 days of these matters. And the urgency that comes with these matters, you will see, because let's say there are wage negotiations in an old age home and they deadlock. Now, when they deadlock, the union is going to refer the dispute to the CCMA. When they get to the CCMA for conciliation, the employer says, we're in an essential service and therefore your right to strike is limited. The union says, no, we're not. When they come to us, the CCMA is waiting in order for it to give a certificate to strike or not. So there's a very high degree of pressure in doing these matters, putting them to finalization and sending them back. Now, the ESC hears these matters between 2 days, which is 48 hours, to 7 days. So we try and hear it immediately in line with what the Act says, dispose of it, report back to the CCMA, and the CCMA can finalize its process. Section 75, as I indicated, is a maintenance service. A maintenance service is defined as a service. A service is a maintenance service if the interruption of that service has the effect of material, physical destruction to any working area, plant, or machinery. These are the huge plants and machinery that are mostly in mines, and you'll see most of the 75s that we've done are in mines, and those machines must be kept going 24/7. They can't be switched off. So if there's a strike and those employees are off that machine, there might be material damage to those machines. Just some interesting facts, and I might have covered some of these issues. Through monitoring and evaluation, the AEC found that some strikes in the public health and local government could have been avoided had the parties' dispute resolution processes had the clause on enforcement. I've already raised the issue with this. We've raised it with the CCMA director, who's also our accounting officer, and the matter is being attended to in relation to the accreditation of those bargaining councils. Also, there's a new trend of employers running out of funds before the end of a financial year and the employees downing tools due to non-payment. This is very important. I went to do a monitoring and evaluation exercise only to get data to find that it was not a strike as defined in the Labor Relations Act. This was a contractual issue where the employer says the funds for the financial year, in local government, the financial year ends in June or July. And they would say in March, we've run out of money, so we can't pay you. And the employees say, if you can't pay us, we are not going to come to work. Now that's a contractual dispute. It's not a strike as defined in terms of the Labor Relations Act. The challenges, Cameron has painted this out. I'm not going to take time on it. We are seeing a culture in the country where there's a rollout of unprotected strikes with no consequences. So people in essential services will go on strike. They know they're not supposed to all go on strike if they have an MSA. And if they don't have an MSA or an MSD, they must work. But they will go on strike, and in old age homes, the elderly would be exposed. In hospitals, the patients would be exposed, and there are no consequences. Also, the enforcement of essential services law is problematic. We don't have an enforcement leg, and that gives us some problems. Also, the provisions of Section 72(5) of the Labor Relations Act, as I indicated, that that section with the amendments now requires people to ballot for an interest arbitration, which we think is not the intended purpose. We've raised the matter with the Department of Labor, and we are quite satisfied that in the next set of amendments, the matter will be dealt with. The assistance that we require, we think that the committee the portfolio committee can help us in this quest of ensuring that there are consequences in cases of unprotected strikes in essential services. We certainly think that it's something that we need looked at. We would also, we think that it's important. I know that the portfolio committee sometimes has roadshows and so forth, that minimum service agreements and minimum service determinations are promoted so that people understand that what they seek to do, those amendments in the Labor Relations Act that gave more value on minimum service agreements, seek to restore the right to strike for employees who did not have it before. Remember, before 2015, if you are in an essential service, you are in an essential, there's nothing you can do. It means the whole, let's say in a hospital, there's 1,000 employees in a clinic. All 1,000 of you can't go on strike. Now, what the amendments have done and what MSAs seek to do is to say out of the 1,000, maybe you can allow 400 to go to strike. So it's actually an achievement. But the way sometimes it is seen is that how is the strike going to be strong? We want everybody in order for us to make sure that the strike is effective. But in essential services, you can't have everybody because you are taking care of life, health, and personal safety. We're saying we would be assisted by possible legislative changes in the following areas. One, enforcement of ESC designations and determinations, something similar to the current Section 143 of the Labor Relations Act for awards. Section 143 deals with awards and talks about how to enforce them, but we don't have a legislative arm for enforcement of our ESC designations as well as determinations. Number two, the rescission of ESC designations and determinations. Again, currently the Labor Relations Act provides only for variations and not rescissions. The CCMA has got Section 144 of the Labor Relations Act, which provides for both. We have just one. And then lastly, the amendment of Section 72(5) to allow parties to voluntarily refer their matters for interest arbitration, as I've indicated. Chair, as I complete my presentation, I'd like to introduce the full committee, the ESC committee. I'm deputized by Joyce Ngopane, who's a senior commissioner at the CCMA. And then we've got two members per sector. We've got Advocate Makubalo Ndaba and Mr. Clement Marule, who are our labor reps. They are ESC members. Advocate Ndaba comes from Pope Crew, Clement comes from Nehau. And then we've got two government reps, Advocate Memani for provincial and national government. And then we've got Mr. Zwen Dala from local government, comes from the South African Local Government Association. And then we've got two business reps, Aruna Ranchot, as well as Dr. Geldenees, business reps, as nominated by Busa. So that's the committee, Chair, and I am done. Thank you very much. I will now take questions, and the rest of the committee may also assist with responses. Thank you.
Thank you very much, Advocate Bono. Thank you very much. Any Any comments, questions? Okay, can I just ask now? I want to ask where you go and say support services in the health sector. Which are those?
Yes.
Support services in the health sector that you classify them as essential. You say nurses, you said medical, and you said support services. Which are those? Is it
I'm gonna
admin?
give them to you now. I'm gonna give them to you now. Chair, if you bear with me. I just want to get to the actual designations so that I don't tell you things that are wrong. Those would be catering, those would be medical records, those would be security, porter and reception, pharmaceutical and dispensary, medical quality and control laboratory, forensics, laundry, clinical engineering, hospital engineering.
So the entire system, because you
no.
That's right.
We would leave people who are working in HR. We will leave those are not essential. People working in finance are not essential, and so forth.
One question will be, if you say there are no in unprotected strike, no consequence management, who are to take responsibility in terms of the unprotected strike? Who is to take responsibility? If you say
somebody, I must okay. I must think twice.
My last one, so that my last one, so that you answer all of them, not one by one. What then becomes the role of the trade union in ensuring that? Is it only maybe I'm asking because it can't be only the role of the trade union. What has been your experience? Let me rephrase. What has been your experience when you are intervening in these strikes? In terms of the role of the employer and that of the trade union, what has been experienced in empowering their role in how have they conducted themselves in ensuring that their members and the staff in terms of the employer are empowered to understand the do's and don'ts and all these acts. Do you have any experience?
Yeah, we do, Chair. We do. The monitoring and evaluation tool that we use.
And I'm sorry, in which is it in local government or is it in public health or in whatever? Yeah.
Sure. As I said, Chair, we do the monitoring and evaluation tool that we have. Ask some of the questions that you've raised. One of them is, do you need information? Do you want training? We've conducted workshops for them so that the next time a similar thing happens, they know how to deal with it. Let me give you a practical example. There was in 2019, if you recall, there was a house strike in social development, which led to one person in Limpopo, I think, passing away. What many people do not know is that a few days before that strike, Nehao came to us and wanted to have a minimum service agreement done because they knew that it's part of the requirements. Unfortunately, it's not something that you can do in 2 days or so. So what we did was we convened a meeting with the DG in the Department of Social Development and with NEHAU to try and see if we can put an MSA quickly, but it proved to be impossible because it was big. And when we proposed that the strike be moved, we were told the buses have been booked, everything is done. It would be difficult. So to answer your question, the parties, some of the parties know, I must say, I can't answer for all. Some of the parties know that if you're going to engage in a strike in an essential service, you need to have a minimum service agreement or a minimum service determination. We have often found that in some strikes, it's the fault of the employer. I mean, a classical one is the municipality in Stataram, Amahlati, where they ran out of money. A second example is Amatola District Municipality, where they've run out of money. So you find that the employees are frustrated and they resort to strike. We also have positive examples. There was a strike in the Joburg Metro Police way back, and I think it was 2016. Joyce would remember that. And that strike, the traffic officers complied with the minimum service agreement. So we do have good examples as well. Although in many cases you would find that there's no compliance. And your first question was who's to take responsibility. I think it depends. It depends if it's an industrial action that's as a consequence of the employer's actions, then obviously it's the employer that's at fault. But sometimes, where it's an unprotected strike, it means that surely the unions or labor has not followed the correct process in ensuring that the strike is protected. Thank you, Chair.
Okay. Honorable Mkhonto, your hand is up.
I see there's a hand from Kosi. Mm-hmm.
Yeah, Honorable Mkhonto.
Thanks, Chair. Thanks, Chair. In fact, I wanted to ask questions before you did. Unfortunately, you did not see my hand. I'm a little bit covered, Chair, because I wanted to check with you, Advocate Bono, as to how does the CCMA ensure that employers do not abuse the essential service concept when they become reluctant to address workers' demands, because they know that because they are in essential services, there are quotas of them that have to perform, and if their performance is satisfactory in that particular point in time, then the employers can easily get reluctant to address the demands of the workers. So how does CCMA ensure that that does not happen? The demands of the workers, if they are genuine, they are addressed. And then, Chair, we all know in this committee that CCMA is one of our entities that are working very, very hard. You can feel their work wherever you go. But this is a general question. The challenge that I always encounter, Chair, is when CCMA is giving rulings and employers, if those rulings are against them, they don't implement them. And workers become frustrated. They don't know what to do thereafter. So maybe it's something that we can discuss with Advocate Bono after this meeting, because it's a really serious matter. CCMA is working, but workers do not comply. And then I wanted to also check with Advocate Bono. Funeral people that are engaged in funeral services, can they be classified as essential service? Why am I asking, Chair? I got a call from one of them when the issue of COVID-19 vaccine, the president of the country said they will start with frontline workers and essential services and so forth. So these people were calling and asking if they can be classified as essential services under this COVID-19 pandemic, so that they are able to get the vaccination as early as possible. But my question is, can they be classified as essential services, even in hospitals? Thank you.
Honorable Bono, you may respond. Advocate Bono. Zolan Kwenzekandoni.
Chair, Advocate Bono was here.
Are there any commissioners that are around that can respond?
We are here. I just don't know if the Deputy Chair wants to respond.
If the Deputy Chair wants to respond, it's fine, she may.
Yes, oh, thank you, thank you, Chairperson. I was trying to unmute myself. Let me start with the last question, the one of the funeral parlors. In terms of the Disaster Management Act, they probably are designated as essential services, but I think it is important for us to always understand and draw a distinction between essential services that are designated by the committee or in terms of the Labor Relations Act, and those designated in terms of the Disaster Management Act. So from the committee's side, the only service that has been designated as essential services is forensic pathology. For instance, if you look at the mortuary services, particularly the government mortuaries, those have been designated as essential services. And on the issue of whether they will get the vaccine, I suppose they will, because they are in mortuaries in public hospitals, and they would qualify as frontline. But as to those that are in private, your funeral parlors, I think it will be for the Command Council who determines who gets vaccinated first to determine that issue. But from our side, I can safely say that those that are in mortuaries, they have been designated and they are rendering essential services for the purposes of the Labor Relations Act as well. The second question, Chair, I'm not sure whether I should answer. I will not be giving this answer as a spokesperson for the CCMA. However, I will try from a point of view of myself being a commissioner. I'm sure when Advocate Bono introduced me, Advocate Bono did indicate that I'm also, by my position, I'm also a senior commissioner at the CCMA. So in terms of non-compliance by employers, where there's an award or a ruling that has been made by the CCMA, Chair, there's a mechanism in terms of the Labor Relations Act to enforce those awards. And I must say that from the Department of Labor, I think funds were made to the CCMA for the CCMA to assist employees. If an employee can show that they cannot afford, for instance, the fees of the sheriff, you have an award, and this is an award for money to be paid to you, and the employer refuses to comply, the CCMA is able to assist you in terms of that enforcement process. And with the amendments that came as well, unlike before, where people were required to go to court, this is no longer the situation. You can go back to the CCMA, and the CCMA has a department in the post-hearing department that assists in terms of making sure that they assist the employees to enforce those awards that are given by the CCMA. In terms of the frustration that comes, this is the first question that was asked by Kosi, the honorable member Kosi. I'm not sure, I don't want to misspell the same name. On my screen, it doesn't appear fully, Madam Chair. In terms of the very first question that she asked relating to the reluctance of the employers to give in to the demands of employees, because now they know that these employees are rendering essential services, effectively saying, will the employers not take advantage of the fact that employees have been designated as essential, or the services have been, that is rendered by the employees has been designated as essential, and therefore we don't have to meet their demands. The employees are not left without a remedy. And the reason why, as a committee, we advocate these minimum service agreements is to say that when there's a minimum service agreement, at least some of the employees are allowed to go on strike, and that can exert pressure. But it does happen, particularly in your small institutions, where when you look at the minimums, I think the challenge is that even if they can go on strike, those that are identified as a minimum, it will not exert that much pressure on the employer to give in to these demands. And this is where then, when you look at the law, the ILO speaks of compulsory guarantees, where you're taking away the right of employees to strike. Because, the sanctity of collective bargaining is recognized there. And in South Africa, Chairperson, we also have, and we also recognize, so we do have that, I think it's compensatory guarantees. We do have that kind of a mechanism in our Act. Section 74 of the Labor Relations Act then talks about interest arbitration. So where employees realize that in this instance, we cannot go on strikes, maybe because we do not have a minimum service agreement and the services that we are rendering have been designated as essential services, those employees do have a right, when they deadlock at the CCMA, to refer this matter to an independent arbiter at the CCMA to arbitrate that particular matter and to then determine the issues of mutual interest where the parties are unable to agree. Chairperson, I think I tried to answer. If the members present here want to add, they may, but I think that I've tried to answer all the three questions. Thank you, Chairperson.
Sorry. Okay, I saw Advocate Bono. I don't know whether he's back, but if other members want to add, they will. I'm not quite sure, Honorable Mkondo, is your hand still up?
I'm sorry, Chair. I forgot to lower it. It's lowered now. I'm covered.
Okay.
Okay, thanks.
Advocate Bono and your team.
Covered all questions. Let me just take Portfolio Committee together with the Department of Employment and Labour for allowing us the opportunity to come and explain to the Portfolio Committee the work that we do, what we have achieved so far, what our challenges are, as well as how we think we can be assisted. Thank you, Chair.
Okay, no, thank you very much, honorable members. DM, can we agree, DM, that are you here tomorrow? TM, are you here
Yes,
tomorrow?
I will join you, Chair.
Okay.
Yes, I'll definitely join you.
Okay. Yeah, let's agree that then when tomorrow we are rounding up, we'll give the minister and yourself the opportunity. But it seems as if we at least now we are quite clear, so that we are not taken by surprise as this committee, because at times people do ask, but what is employment and labor saying about, what is employing and labor's views about? So that is why I thought that it is important that we then become empowered on some of these issues. Having said that, honorable members, we are meeting tomorrow again at 9. I'm not quite sure whether the link will still be the same.
Yes, Chair, it's going to be
And
the
I
same.
hope and I hope it's not going to give us the problem that it gave us this morning, some of us. We will meet again at 9, because we're then going to have a presentation on the bargaining forum processes that are happening within the labor space. Again, with an understanding that we wouldn't be PSCBC. It will be out of the presenters if they think that there is something that we will need to be empowered on in terms of the pay. But PSCBC, we all know, fall under the ambit of the public service and public service and administration. Having said that, honorable members,
Sorry, Honorable Chair.
will,
Honorable Chairperson, my
yes,
apologies. I'm just realizing now that I forgot that we've got the NEC meeting of the ruling party tomorrow and Sunday. So it will be difficult for me to join both. So my apologies in advance. So I think the minister will join the workshop tomorrow.
Oh, okay.
Yeah,
Okay.
it's clashing. I'm
No,
just
thank
looking at my program for tomorrow. My apologies.
No, thank you. No, thank you. No, thank you, TM. Otherwise, honorable members, until we meet again tomorrow at 9 o'clock, our workshop stands adjourned. The business of the day.
Thanks,
We are
Chair.
done.
Have a nice day.
Thank you, honorable members.
Thank you, Honorable Chair. Thank you, DC.
Sorry for messing up your Friday, but we don't have any other option. Each job. Sure.
Bye.
Bye.
Awuqhubile ngale workshop qhube ure.
Go, sis. Go.